Yeah, fine.
Statement.
Yeah,
happy to lead.
He can't just stand up, Mr. House, even if he's an expert, and start saying, Mandela did this and this. You've got to lead him. Are we agreed?
No, we're not in agreement, my lord.
So what do you suggest we should do, Mr. Mshololo?
My lord, the state had finished leading evidence in examination in chief. When the questions arose of whatever evidence that was being requested, my lord, the state had already finished the examination in chief.
That's what I understand it. Did you lead all the evidence in chief?
Well, there is so, my lord.
And then what happened thereafter?
And the defense started with cross-examination.
Right.
Mr. Mgomezulu conducted his cross-examination and finalized it. Then Mr. Ramosepele, Advocate Nesi.
Right.
Then when it got to Advocate Numalo, he then indicated that he needs further information.
Information, right.
Yeah, so it is at that point where the proceedings were then adjourned. Hence I was suggesting that perhaps Colonel Hos can just merely put the information on record.
Which he did not put on record in his evidence in chief.
Yes.
Is that not so, Mr. Mshololo?
Thank you, my lord. At least the state has clarified this.
I clarified it.
Thank you, my lord. At least the court has clarified, my lord, that the state had finished its examination in chief. Now we're in the middle of cross-examination when the information was requested, my lord.
Right.
And therefore, after the witness has been able to secure the information that was being requested, then the cross-examination has to continue.
No. Then this witness must adduce evidence regarding the evidence which he had to get in hand. Is that not so? Then thereafter you all start your cross-examination from the beginning. Nobody is prejudiced.
No, my lord, at least I've placed
it on... No, you don't understand.
At least I've placed it on record, my lord.
Wait. You see there are new affidavits.
Yes, my
3 of them. Is that not so?
Yes, two.
Two, and they're made by Mr. House.
Yes.
How do we get them on record?
My lord, the examiner will lead the witness according to those evidence and according to those statements
that have been... Is that not evidence then? That's... Baloyi leads this witness on the evidence which is encapsulated in the affidavits, the new affidavits. Is that not how you understand it?
No, my lord, we've got different understanding. I'll rest my case, my lord.
Okay, and this is...
May I make a submission?
All right.
My goodness, Mzansi, what a morning. Court started off ready, okay? The pot is hot. It is on fire. And the chef was ready to serve. But Mshololo said, not today. I don't want any breakfast. I don't want anything that you're serving. That is not how it happened. Good morning, Mzansi. Remember the housekeeping rules. Please go ahead and like this video. Why? Because we have a lot to unpack today. And today, this video, we're going to start with Mshololo and how she showed up and showed off and put Judge Ratha, Judge Van Ratha and Advocate Baloyi in their places. This is how it began. So, the cooking session, the ingredients, and all the reason why the trial got paused, or should I say postponed, over a week ago. It is because there were issues with 205s when Host was on the stand and he was now saying things that nobody knew what he was talking about. So now they needed all the evidence to be produced to the defense team. And if you're not already up to date, there are so many videos on my channel where I bring you up to date. Today, we have to rush through this because there's just so much to unpack. Okay, so Mshololo, at some point, Judge, at the beginning, okay, just starting out, Judge Ratha out the gate is trying to squeeze in a few new ingredients. He's trying to squeeze in the affidavit, and he even calls it the new affidavit. And then he says, he's just about to close. He's about to land his plane. And he says, okay, so are we all in agreement? And Mshololo takes the mic and she stands up and she says, no, We are not in agreement. And she said that, guys, and I'm saying it verbatim, okay? I'll repeat. Mshololo stood up and said to Judge Ratha, a whole honorable sitting judge with 50 years of experience, and she stood up and said, no, we are not in agreement. That is not how it happened. She then begins to recount to say the state had already finished the examination in chief. Why? Because Baloyi and Ratha were trying to get the state to, cook and put in the evidence on record. And Mshololo said, not today, okay? Not on my watch. We are not eating what you're dishing. No, never. I don't want. Woo! Amazing, okay? It does not stop there. Ratha cuts her off and he says, no, that's not my understanding. I'm telling you guys, this was like a tavern fight, okay? Not even a courthouse. And he says, that is not my understanding. And then he says, he looks at Baloyi, because Baloyi is back in the courthouse, and we all know Judge Ratha always checks in on Baloyi. And he says to Baloyi, did you lead the evidence in chief? And Baloyi, who can never answer a simple question with a yes or no, walks us down the route of how it all happened. And he explains quite slowly, if I might add. He explains from the beginning that, well, I led the evidence. And then after that, Ngomezulu, and he goes down the line, okay? And then he explains where they pause. And then, and then Mshololo, and then Baloyi sits down, and then Mshololo stands up and says, thank you, my lord, at least. Now, Mshololo has gained, I don't know, some courage, but she's coming through with the courage, and she's coming through with the jabs at the state. And she says, thank you, my lord. At least the state has clarified this. And Ratha jumps in right away and says, I clarified this. A whole wow. But Mshololo knows how to pick her battles, so she lets that one slide. There's no point arguing that one. The fact of the matter is, it is now on record that the state had concluded their chief examination, or their examination in chief, which is what she was trying to tell the judge in the beginning, okay? Now that Ratha claims he's clarified everything, he goes on to say she goes on to say the state has clarified that they had finished, okay? AKA, she's literally saying, I already told you this, but you don't listen to me because I'm a woman. I don't know what your bias is, but I'm clocking you right now. And then Ratha goes on to say, so that nobody says there is prejudice, because the state and Baloyi and the state and Judge Ratha are now very, very defensive human beings. And he says, so that nobody says there is prejudice. And Mshololo says, at least I have placed it on record. And she says that twice. Again, the defense team is getting ready to appeal whatever decisions this judge makes. That's why they keep putting stuff on record, and now that's why they keep objecting to things. And Ratha says, so how do you expect us to get the two new affidavits that Holst has produced today, all of a sudden? How do you expect us to get these on records if you guys won't let Baloyi examine in chief Holst again? And they say, we do not care. Okay? Now, Mshololo did her part. Nisi takes the mic to say, listen, I'm going to make some submissions. I'm going to make a reasonable submission. But Ratha immediately shoots him down as well. And here comes Ngomezulu to save the day. I love it when the defense team is working together. That's it. Let me just comment down below your thoughts on what just happened in this intro this morning. And then I'm going to go ahead. Let's listen to this yourself. Listen to Nisi, listen to Ngomezulu, and I'll be back with the rest of my commentary because Guningi, and it is a lot. It's been a long day. Oh, highlight, or should I call it boiler alert? Ngumalo is showing off today. Okay.
All right.
The court will recall that actually I had not finished my cross-examination.
I know.
Yes.
Yes.
Now, subsequent to the cross-examination of Mr. Holst being pended, it transpired that there is a new information that the state wanted to put on record.
Right, fine.
As if that is evidence in chief.
Right?
So what I suggest should then happen now is that we should finalize our cross-examination. If there is any further new information that the state would want to put on record through Mr. House, then the state must make that application to recall Mr. House and put that new information into record, and then we all then get afforded the opportunity to cross-examine him on that new evidence. As opposed to the state...
Okay, fine. Now this new evidence, is it going to be recorded in this court?
That will depend on the application that the state is going to make in recalling Mr. House to put that new evidence on record.
Now, according to
because
you,
this is new evidence altogether. It's not a continuation.
Listen, your submission is the cross-examination of this witness should continue from where you ended.
Yes, madam.
Up to Ms. Mshololo.
We'll finalize
And
it.
what
yes.
happens thereafter?
Then the state makes an application to recall Mr. House to
No, but
introduce that
this
new
witness, this is the
evidence.
problem you have. This witness, once you are cross-examining him,
Yes.
he may refer to these affidavits. Am I right, House?
That's correct.
I'm long in the game. And how do you have recourse to these affidavits when he refers to them there, when he hasn't led them in chief in terms of 167? Are you with me?
The challenge, my lord, in that regard is, it has never happened that a witness was under cross-examination at the same time is also led in evidence in chief. It's a very precarious process because
Okay,
the cross-examination must be done up until the end.
I've done it a million times, fine.
As it is the court, madam.
And
Thank you.
it's lawful, by the way. Continue with your cross-examination then. They say if you want to, you will recall this witness.
To me, it's really compartmentalizing the issue.
No, fine, but the general principle is, if a witness proffers an answer to evidence which he hasn't led in chief, but which he has subsequently deposed to in an affidavit, he can refer to it. You can't stop him and say, you didn't say that in chief. Please, I'm making that ruling.
Yes.
Right, let's continue then.
Yes, just maybe one point. The fact of the matter is the defense criticized the witness for not having shown communication between the accused. Now, he has done that, and I think, to me, the practical solution would be for him to then place that information on record to say, listen, we have since gone and compile that information that the defense has requested, and then everybody gets opportunity to cross-examine. That will, in my view, be a practical solution.
Mr. Gomezul, I see you're shaking your head.
My Lord, I would actually make a submission to concur with Advocate Mzansi in the sense that basically, and what is a principle of law relating to these procedures, it relates to prejudice. My submission is that I concur with Advocate Mzansi. Let the cross-examination proceed as it has carried on, because that's when, if the state brings the application now to listen to the new evidence, that's when the defense will determine whether there's prejudice against the accused.
I've also heard, Mr. Mzansi. Have you ever in your career heard of a court recalling a witness? Have you ever heard this?
Yes.
Not even consulting the defense.
The court, yes.
Yeah, it's section what? 167.
It's 167.
Then the court can re-examine that witness on the evidence he has said. In other words, I can say, are you aware that in terms of the principles of analyzing cell phone information, you can do A, B, C, and D. I can do that. And it's not me. It's this book. Let's read it. The court may, at any stage of criminal proceedings, at any stage, the court, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance of such proceedings, and may recall and re-examine and at the proceedings, and the court may examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. That's what it says, not me. But we'll do it the way you suggest.
Correct, my
And
lord.
then me, after that, I'll do it in terms of section 167.
Court
Okay,
pleases.
continue, Mr. Nisi.
So Judge Ratha, again, he's done this before in the trial within the trial. He always makes a ruling so that when he comes back to overturn anything, it is already on record. So he already sets the stage that he is going to recall this witness based on section 167, and he reads out what 167 is, that this is essential to the case. How do you know it's essential to the case? He hasn't finished his cross-examination, but you have already decided that you're going to recall him and that it is essential to the case. That is very telling, Judge Ratha, very, very telling. And Gomezulu says, not a problem, but I'm going to let you know right now, I concur with Mnisi, aka as well as Mshololo. We do not want. As a matter of fact, we are going to discombobulate you. Whatever plan you had in that cooking session, we're not going to let it happen. We are continuing with the defense doing the cross-examination. What does that do? That unstabilizes the witness, because whatever they had rehearsed or prepared, the witness is not going to be ready for it, because their plan was that Baloyi goes first, puts in everything they need into evidence, tidies everything up, put a nice cute bow on it, and then bada boom, bada bam. But the defense said, not today, okay? And not today. We are doing this the way we want to do it. So yeah, that is how it happened, that the defense is the one cross-examining host per the old affidavit and the 205s. So it is a very interesting day. Let's keep watching. Thank you for watching. I'll catch you on the next video. It's better for me to compartmentalize these, and so that it's not one long video, because I assure you today is going to be a long day. Thanks for watching. You already know. Remember to like, comment, and subscribe, and do the things that make the channel grow. Thanks for watching.